case I want to talk about here in the ongoing saga of former President Trump's criminal trial here. So this right here, this case I'm going to talk about, or the article rather, that I'm going to talk about, was recorded in the New York Sun. So let's talk about this case right here. According to the New York Sun, Judge Tanya Chukhan's weekend rejection of President Trump's request that his January 6th case be dismissed as, quote, selective and vindictive, close quote, signals that special counsel Jack Smith's prosecution may be down, but it's not out, and could gain new life under a President Harris. The judge, or the ruling from the judge, came fast on the heels of the Supreme Court's returning to the appeals circuit for the District of Columbia the case of Trump versus United States. The circuit then passed it back to Judge Chutkhan. Her task now is to determine which presidential acts alleged by Mr. Smith are official and therefore punitively immune. Unofficial acts are fair game for government prosecution. The timing of Judge Chukhan's decision, delivered as soon as the case returned to her docket for the first time since February, telegraphs that she will proceed or preside with dispatch after months of delay. The case was frozen, but it is no longer on pause. Its return to her courtroom, albeit with the burden of the immunity ruling, is a sign that the January 6 charges are alive. Trump could yet be convicted, particularly if Vice President Harris wins the election. The proceedings, which will involve the summoning of witnesses and adducing of evidence, are likely to take months. Trump's motions to dismiss the case as selectively and vindictively brought would have, had it succeeded, rendered the immunity question moot. Judge Chukhan has denied that gamble and accuses the 45th president of a, quote, improper reframing of the allegations against him. So, Special Counsel Jack Smith is the one who brought the charges originally against him, and there's a photo right there of Special Counsel Jack Smith. Now let's get back to the story. The judge reckons that Trump is peddling an alternative narrative in which Mr. Smith is prosecuting him merely for contesting the results of the 2020 election rather than knowingly making false statements in furtherance of criminal conspiracy, suggests that the 45th president may have won on immunity, but has not persuaded her that Mr. Smith's case is flawed. Trump faces a heavy burden in seeking dismissal at this early juncture. The Supreme Court has held that the decision to prosecute is particularly ill-suited to judicial review and that the government is afforded broad discretion as to whom to prosecute. That is because the choice to prosecute is, the nine have determined, a special province of the executive branch. Courts are required to tread carefully with respect to this prerogative. The 45th president argued unsuccessfully that he met his burden by surfacing public statements from President Biden and news reports sourced to government personnel with direct knowledge of the relevant events that disclose that Messrs. Biden and Smith acted to prevent him from becoming the next president again. This is the judge who is presiding over the New York case. This is the judge who has been threatened by Trump's camp over and over and over again. As you can see, she's African American and she's a black woman. And this is the judge who will decide if this case moves forward or if all these charges are going to be totally dropped. Judge Chutkhan, though, finds no evidence that Mr. Biden directly directed Attorney General Garland or the Department of Justice to prosecute Trump, much less that such comments actually resulted in politically motivated action. She cites Mr. Garland's explanation that the DOJ felt only pressured to do the right thing and follow the facts and the law wherever they may lead. That at least is enough to defeat Trump's efforts to have the case dismissed. Trump was charged first in the Mar-a-Lago case in South Florida, and the charges in this case were only handed up after the 45th president pleaded not guilty before Judge Eileen Cannon. Trump contends that the January 6 case was brought as punishment for his refusal to admit to those crimes. Judge Chutkhan, though, contends that more proof is needed to show that Mr. Smith is motivated by a desire to punish defendant for pleading not guilty in a different case. The judge finds that Mr. Smith's prosecution or prosecutorial action, so across two jurisdictions, did not raise the red flag of vindictiveness, and that the charges in this case appear unrelated to those brought against defendant in the Southern District of Florida. That case was last month dismissed by Judge Cannon, who found that Mr. Smith's appointment by Mr. Garland was unconstitutional. That decision does not bind Judge Chutkhan. Judge Chutkhan declares that it cannot be the law that changes or charges handed up against the defendant after the defendant asserts his innocence in another case are inevitably tainted by vindictiveness. The government argues that the investigation by career prosecutors were underway well before the defendant was charged or pleaded not guilty in the Southern District of Florida. The evidence, Judge Chutkhan writes, plainly shows that the government did not conjure up the 4 counts against defendant in this case in the weeks after his indictment in Florida. That is a vote of confidence for the fundamentals of Mr. Smith's case, which now must contend with Judge Chutkhan's application of the Supreme Court's broad rendering of immunity. So this case is moving forward. Whether they like it or not, she's going to follow the letter of the law. So until next time, never surrender, never quit.